Our Heavenly Father, the fount of all goodness and grace, the cause of wisdom, the source of intelligence, we welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope, to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Good afternoon to everybody watching our stream over on Facebook Live. I'm Regina and I am your host for today's bonus lecture for the Best Bar Ops lecture series titled Frequently Asked Topics on the 8 Bar Subjects. This series is brought to you by the Philippine Association of Law Schools in collaboration with Rex Bookstore and Edo Campion. Welcome to our dear speaker, deans, professors, and bar takers tuning into our stream. We're already done with the first day of the exams. How is everybody doing? We hope all our bar takers are using this day to rest, and let us help you prepare for tomorrow's exam with this afternoon's lecture. We're all halfway there, and we are constantly praying for everybody's success. Today's program is a continuation of our last lecture regarding remedial law civil procedure. We will be tackling FAQs that will be determined and answered by a distinguished guest this afternoon, and she has prepared a lecture to help the bar takers as they take the exam of their life. To introduce this afternoon's speaker, Dean Maria Soledad Deriquito-Mawis received her Bachelor of Arts in Political Science degree from the University of the Philippines as cum laude in 1983. Currently, Dean Sol is the Dean of and a professor in the Lyceum of the Philippines College of Law, and also teaches in the University of the Philippines, the La Salle University, University of Santo Tomas, and Adamson University. She is a professorial lecturer too in the Philippine Judicial Academy and a member of its Civil Law Department, a bar reviewer in Persons and Family Relations and Civil Procedure and Evidence, and a mandatory continuing legal education resource person. She is the founder of Mawis Law Office, a columnist at the Philippine Daily Inquirer, a subject matter expert at the IDLO DOJ project on the prosecution of crimes involving women and children, and a co-author of the book on Persons and Family Relations. Without further ado, let's all welcome this afternoon's lecturer, Dean Maria Soledad Deriquito-Mawis.
Good afternoon, everybody. Okay, this is just but a continuation of what we started last time. But this time, I'm no longer going to share with you. I'm no longer going to share with you slides now because I will only speak until 5:30. Let me highlight with you. Let me discuss the highlights of the 2019 rules on civil procedure. Now we're supposed to start with Rule 7 today. Okay, Rule 7 is with respect to deals with parts and contents of a pleading. And one of the highlights of the amendments that I would like to discuss is Section 3, which is the signature and address. Please take note that every pleading and other written submissions to the court, must be signed by the party or counsel representing him or her. And the signature of counsel constitutes a certificate by him or her that he or she has read the pleading and document, that to the best of his or her knowledge, information, belief, formed after a reasonable inquiry under the circumstances, It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. That the claims and defenses and other legal contentions are warranted by existing law or jurisprudence. It is non-frivolous argument for extending, modifying, or reversing existing jurisprudence. The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support and availment of the modes of discovery under these rules. And finally, the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonable based on belief or lack of information. Now, what is important is if there's violation, okay, of this section, then the court may impose appropriate sanction or refer such violation to the proper office for disciplinary action. And what will be the sanctions that may be imposed by the trial court? It can be non-monetary or a directive or sanction, ordered to pay a penalty in court, or imposed on motion and warranted for effective deference, an order directing the payment to the movant of all reasonable attorney's fees and other expenses directly resulting from that violation, including attorney's fees for the filing of the motion or sanction. Now, also, it was also stated in the amendment that as a general rule, a law firm shall be jointly and severally liable for a violation committed by its partners, okay, associate or employee. And the only exception is when exceptional circumstances exist, okay, which will justify the non-inclusion of the law firm. Okay. So it is the duty of counsel to verify, therefore, the truthfulness of the client's pleading and other written submission. Otherwise, the counsel may be held personally liable. Okay. So an unsigned pleading is not deemed as filed at all. Okay. An unsigned pleading, therefore, produces no legal effect. However, the court may, in its discretion, allow such deficiency to be remedied. You know, sa inyong practical exercises, just in case, or you will be required to prepare a pleading, just make sure that on the, of course, hindi pwede yung pangalan nyo, di ba? Kasi ano yan, marking yan, no? Identify. Magpirma, kunwari lang kayo doon, because a pleading that is not signed is deemed not filed at all. Now, if you're asked to prepare, for example, a sample pleading, just prepare a sample pleading, okay? But do not, as I said, okay, make anything that would identify you kasi baka ma-DQ kayo. Now, what is the difference between verification and certification against forum shopping? Okay, a distinction must be made between non-compliance with the requirement on or submission of a defective certification and non-compliance with the requirement or submission of defective certification against forum shopping. As to verification, non-compliance or defect therein does not necessarily render the pleading fatally defective. Okay, it is not a jurisdictional defect. Okay, the court may order the submission or correction or act on the pleading if the attending circumstances are such that strict compliance with the rule may be dispensed with. Verification is deemed substantially complied when one who has ample knowledge to swear to the truth of the allegations in the complaint or petition signs the verification, and when matters alleged in the petition has been made in good faith or are true and correct. Now, as to the certification against forum shopping, you don't comply, okay, there is a defect, okay, unlike verification, this is not generally curable by amendment, okay, and the case will just be, in your petition will just be dismissed, okay, unless, of course, there is substantial compliance or presence of special circumstances or compelling reason. The certification against forum shopping must be signed by all of the plaintiffs. That is the general rule. pursuant to the ruling of the Supreme Court in the case of Luquias versus Ombudsman. However, one of the many parties may sign if, for example, if he has been authorized, okay, and the special power of attorney is attached therein, or if they are being sued, if the petitioners are being sued or share rather, the petitioners share a common interest and invoke a common cause of action or defense, then the signature of only one of them in the certification against forum shopping substantially complies with the rule. Okay. And that is the case of Lucena versus Lapisura. Mag-asawa sila, husband lang ang pumirma. Okay. Anong sabi ng Supreme Court? Substantial compliance. Why? Because the subject matter of the case is a conjugal property. Okay. And as one of the as a co-administrator of the conjugal property, he can sign. They are suing on the same they are suing on the same cause of action. Okay. Now, certification against forum shopping must be executed by a party pleader, not by his counsel. If, however, for reasonable or justifiable reasons, the party pleader is unable to sign, he must execute a special power of attorney designating his counsel of record to sign on his behalf. Okay. Now, okay. If you know, what are the elements of forum shopping? Okay. What are the elements of the forum shopping? Identity of parties, or at least such parties representing the same interest in both actions. Identity of rights asserted and reliefs prayed for, the relief being founded on the same facts, and the identity of the preceding particulars, such as that a judgment in the other action will, regardless of which party is successful, will amount to res judicata in the action under consideration. Now, who executes the certification against forum shopping? The indispensable party, the necessary party. A misjoined party, it should not execute a certificate of non-forum shopping. Now, general rule, it must be the party pleader, not the counsel, who should sign the certificate of non-forum shopping. Exception, if for any reasonable or justifiable reasons the party pleader is unable to sign, he must execute a special power of attorney designating his counsel of record to sign on his behalf. Okay. Paano kunwari ang party is a juridical entity? Then the authorization of the affiant to act on behalf of that juridical party must be attached, okay, to the certification against forum shopping. And what is the best evidence that this person has been authorized by the corporation? Secretary certificate, okay, or a director certificate, okay. Now, what are the undertakings, okay, of a party under the certification against forum shopping? The party has not commenced any action or any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his knowledge, no such other action or claim is pending. If there is such other pending or action or claim that's pending, a complete statement of the present status. And finally, if he or she thereafter learned that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days in the court wherein his or her aforesaid complaint or initiatory pleading has been filed. Okay. Kailan ine-execute ang certification against forum shopping? With respect to initiatory pleadings. Okay. You don't comply with the certification on non-forum shopping, it, as I said, it is not curable by a mere amendment of the complaint or other initiatory pleading, and in fact, it shall be the cause for the dismissal of the case without prejudice. Now, pero kung deliberate, okay, ang forum shopping mo at hindi mo sinungaling ka sa iyong certificate against forum shopping, okay, there's a deliberate, willful, okay, misrepresentation in your certificate, then the two cases will be dismissed with prejudice. Okay. Now, there is one case, and this is the case of the Lima versus Honorable Guerrero. Okay. Without the presence of the notary upon the signing of the verification and certification against forum shopping, there is no assurance that the petitioner swore under oath that the allegations in the petitions have been made in good faith or are true and correct, okay, and not merely speculative. Kasi ito, nagkaroon ng certification ng non-forum shopping. It turns out pala na wala naman pala yung notaryo doon. Okay? So what happened? Okay? The Supreme Court said in the case of Dilima, the absence of the notary public when petitioner allegedly affixed her signature also negates a proper attestation that forum shopping has been committed by the filing of the petition. Thus, the petition is for all intents and purposes an unsigned pleading that does not deserve the cognizance of the court. Okay? Now, if, non-compliance with any of the undertaking or submission of a false certification, what is going to happen? It shall constitute indirect contempt without prejudice to the corresponding administrative and criminal cases. Now, if it's deliberate and willful, what will happen? Then it will cause a dismissal of all the complaints with prejudice. As I said earlier, the certificate of non-forum shopping should be executed when you're talking about initiatory pleadings. And what are the examples of initiatory pleadings? Permissive counterclaim, the complaint, the original special civil action for certiorari, prohibition on mandamus. Now, clear. Now, when we talk about manner in making allegations, the 2019 rules on civil procedure, there are two kinds of facts under the rules on pleading. The first one is your ultimate facts. The second one will be your evidentiary facts. As I said, I'm just discussing the highlights of 2019 sa haba. What do you mean by ultimate facts? The ultimate facts refer to the essential facts of the claim. A fact is essential if it cannot be stricken out without leaving the statement of cause of action inadequate. So your ultimate facts do not refer to the details of the probative matter or to the particulars of evidence. They are what? Basically, the ultimate facts are those allegations that would constitute your cause of action. How about, evidentiary facts? When we speak of evidentiary facts, this one naman refers to facts which are necessary for the determination of the ultimate facts. They are the premises upon which conclusions of ultimate facts are based. Under the 2019 rules on civil procedure, both kinds of facts must be alleged in every pleading. If upon the filing of the pleading, evidentiary facts are yet to be discovered, a statement must be made that the evidentiary facts will be produced through the modes of discovery. Now we can do away with, I will leave up to you alternative causes of action, and let me just discuss conditions precedent. Condition precedents are matters which must be complied with before a cause of action can arise. When a claim is subject to a condition precedent, the compliance of the same must be alleged in the pleading. Ano mga examples ng conditions precedent? Tender of payment is required before making consignation. Exhaustion of administrative remedies before you can resort to judicial action in some cases. 3, barangay conciliation. That's very important. If you live in the same city or the same municipality, before you can file a case against your neighbor, especially if it's a collection suit, you have to resort to the barangay proceedings. Bago kayo mag-file ng unlawful detainer or forcible entry case, dapat mag-barangay muna kayo if you live in the same city or municipality. Earnest efforts towards a compromise must be undertaken when the suit is between family members. And in fact, there were no efforts made, the case must be dismissed. But kung meron na, magkapatid, nagdimandahan, pero sinama si brother-in-law, the case will now, there is no need for you to resort to earnest efforts to arrive at a compromise settlement before the filing of the case, because there's already impeded a stranger to the suit. Arbitration may be a condition precedent when the contract between the parties provide for the arbitration first before recourse to judicial remedies. Capacity. Only natural and juridical persons can be sued or be sued. Facts showing the capacity of a person to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association, okay, must be averred. Okay. You know, okay, what is the capacity? When you talk about capacity of the persons of a natural person, capacity to sue or be sued when the person is of legal age. Kailangan i-allege mo yan. Na kung minor, must be representative by parents or guardians. Kung insane, must be represented by guardian ad litem. Okay. When you're talking about a domestic corporation, you have to allege the required capacity. And what is that? That the domestic corporation is organized and existing under the laws of the Republic of the Philippines. Iba naman ang rule pag foreign corporation. To have the required capacity, a foreign corporation must be organized under a foreign law and is licensed to do business in the Philippines. You have to allege that. Or if it's not doing business in the Philippines, you must allege that it is not doing business in the Philippines and that the foreign corporation is suing under an isolated transaction. And therefore, it should not be engaged in doing business. Okay. Now, in the case of Steel Case versus Design International, the Supreme Court ruled that one act appointing a representative distributor domiciled in the Philippines which transacts business in, okay, the representative's own name cannot be deemed as doing business in the Philippines. Now, there's a whale of a difference between lack of legal capacity to sue and lack of personality to sue. When you say lack of legal capacity to sue, you are referring to the plaintiff's general disability to sue on account of minority or insanity. That the plaintiff does not have the qualifications to sue. You remedy, you file an answer, and raise lack of capacity to sue as an affirmative defense. Lack of personality to sue basically is saying that the person is not the real party in interest, that the plaintiff is not the real party in interest. What is your remedy? You file pa rin an answer, but this time raise as an affirmative defense that the complaint fails to state a cause of action. Okay, now, let me now go to actionable document. Let me go to actionable document. Yung actionable document, kasi this is my personal assessment of what is happening based on what happened in the bar yesterday. Notice that the questions are really, really basic. Okay, really, really basic. So go back to the basics. Now, what do I mean by basics when it comes to civil procedure, given that it has been amended? Okay, you have to know the text of the law. Okay? It's going to be textual because wala pa siyang jurisprudence dun sa pagbabago. Okay. Pero, okay, doon naman sa hindi na bago, always remember the jurisprudence. Kaya hina-highlight natin ano yung mga pagbabago para pag ang tanong tungkol dun sa revisions, just go textual. Okay. The concept of actionable document has not been changed, but it has been made clearer. Okay, what do I mean by that? What is an actionable document? It is a written document which is used as basis for the cause of action or for the defense. And when you say an action or defense is based on an actionable document, the substance of the instrument of the document shall be set forth in the pleading and the original or a copy of the document shall be attached to the pleading as an exhibit. Now, always remember what I said last time. You only file a reply when you want to deny the due execution and authenticity of an actionable document which serve as the basis of the defendant's defense. Now, if the reply, is likewise based on an actionable document, you are allowed to file a rejoinder, a surrejoinder, And the surrejoinder, you can be filed if you want to deny the due execution and authenticity of an actionable document that was the basis of the plaintiff's reply. Okay. How do you now deny the due execution and authenticity of an actionable document? Number one, by specifically denying the due execution and authenticity of the document under oath, and by setting forth what the party claims to be the facts. So when an action or defense is founded upon written instrument or attached to the corresponding pleading, the genuineness and due execution of the instrument shall be deemed admitted. Okay? If you did not deny it under oath, okay, it is deemed admitted. You can no longer, okay, assail the due execution and authenticity of the said actionable document. Okay. Mere statement, therefore, that defendant specifically denies, the allegations contained in paragraph 3, specifically with respect to the due execution and authenticity of the document, period, that is not enough. Okay, that will be deemed a technical admission because that is not an effective denial. First, you have to state the reason why you're denying, and it must be done under oath. Now, when is oath not required? The requirement of specific denial under oath will not apply if the adverse party does not appear to be a party to the instrument or compliance with an order for inspection of the original instrument is refused. Okay. What is technical admission? The failure of the party to specifically deny the due execution and authenticity of an actionable document will give rise to a technical admission that the said document is genuine and is duly executed. So if the answer does not comply with the requirements of the specific denial, the answer therefore fails to tender an issue. Therefore, pag fails to tender an issue, ano mangyayari? Pwede magkaroon ng judgment on the pleadings. Okay. Now, what do you mean by genuineness? Genuineness, it means that the instrument is not spurious, okay, or is not different, okay? What do you mean by due execution? The signature in the document is voluntarily and knowingly affixed. So therefore, it is genuine. And that the party who executed the document had the authority to sign that document. Now, what are the defenses that are cut off by the admission of genuineness and due execution? When a party is deemed to have admitted the genuineness and due execution of an actionable document, defenses that are impleaded from the said admission are necessarily waived. Okay. And what are those that are waived? Forgery, lack of authority to execute, party charge, signed, and document in some other capacity, that the document was never delivered, okay, or that the document was not in the words and figures set out in the pleading. Okay. Okay. Now, what are the defenses that are not cut off by the admission of genuineness and due execution? Hindi na deny under oath, pero walang technical admission. Pwede mo pa rin yan ilabas as defenses. Payment or non-payment. Want of consideration. Illegality of consideration. You can raise it. Usury, fraud, statute of limitation, duress, imbecility, mistake, minority, compromise, and estoppel. This enumeration, these defenses I mentioned, are not inconsistent with the admission of genuineness and due execution. Okay, clear. Okay, now, we go to specific denial. Ang kailangan lang natin tandaan talaga sa specific denial ay ito. When you just say, I specifically deny the allegations contained in paragraph 1, period. Hindi mo man lang in-explain kung bakit mo dinideny. Admission yon. Okay. So you have to say, specifically deny the truth of the matter being that, and you state the reason why. Or I specifically deny the allegations contained in paragraph 3 for lack of information sufficient to form a belief as to the truth or matter there. Now, but there is one case, and this is the case of Capital Motors. Basically, ang sinabi, nangutang si defendant, okay, hindi nakabayad. But what did the defendant do? He just specifically denied everything for lack of information sufficient to form a belief as to the truth or falsity thereof. So sabi ng Supreme Court, it is within your knowledge to know whether you executed the promissory note or not. But by just giving a blanket denial for lack of information sufficient to form a belief as to the truth or matter thereof, okay, that would constitute an admission. Because this time, your denial is not genuine. You ought to know whether you have executed the promissory note or not. Okay, now, allegations not specifically denied, deemed admitted. So the material allegations in a pleading asserting a claim or claims are not specifically denied are deemed admitted. Okay. Allegations as to the amount of liquidated damages, unliquidated damages, however, are not admitted. Okay, now, let me now discuss Section 12 of Rule 8. Okay. Notice that the former section, Rule 16, yung motion to dismiss, nawala na yan. Okay. Ano ang nangyari? Okay. 4 grounds: lack of jurisdiction over the subject matter, litis pendentia, res judicata, and statute of limitation. You can raise that in a motion to dismiss. My basis, Rule 15, Section 12. All the other grounds mentioned under Rule 16, such as, okay, lack of jurisdiction over the person of the defendant, improper venue, that the complaint fails to state a cause of action, and the rest, okay, you have to raise it as an affirmative defense in your answer. In other words, pag tinanong, kunwari, okay, there's a complaint, may improper venue, okay, anong remedy mo? Huwag mong sasabihin motion to dismiss kasi wala na yon, di ba? 4 lang ang pwedeng motion to dismiss. Lack of jurisdiction over the subject matter, litis pendentia, res judicata, and statute of limitations. The answer there is file an answer and raise in proper venue as an affirmative defense. Okay? Is that clear? Okay. So defendant must file an answer and raise as affirmative defense the grounds mentioned to the former Rule 16. These grounds may be fraud, okay, statute of limitations, release payment illegality, statute of frauds, estoppel, former recovery, discharge of bankruptcy, and other ways of avoidance. Okay, you can also raise, if you like, lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription of claims. Okay. Now, what happens, okay, if your motion, if you're affirmative, what will the court do, okay, when you raise an affirmative defense, okay? Now, what the court's action will depend on the affirmative raised by the defendant. If the affirmative defense was any of the grounds mentioned under Rule 8, Section 12, then the court shall on its own resolve the affirmative defense raised in the answer within 30 calendar days. Ano ba yung nakalagay dun sa Section 8, okay? Section 12, Rule 8, okay? Kunwari, lack of jurisdiction over the person of the defending party. Venue improper delay. Plaintiff has no legal capacity to sue. The pleading asserting the claim states no cause of action and a condition precedent for filing the claim has not been complied with. The court on its own can decide it, okay? It need not be calendared. In fact, under the rules, it should resolve the affirmative defenses raised in the answer within 30 calendar days. Ngayon, kung ang ground naman na ni-raise mo by way of affirmative defense ay yung nakalagay sa Section 5B1, okay? Ano naman yung 5B1? Fraud, statute of limitations, release payment illegality, estoppel, former recovery, discharge of bankruptcy, and other way of confession or avoidance. The court shall on its own, okay, the court may conduct a summary hearing thereon within 15 calendar days from the filing the answer, and then the court shall resolve the affirmative defense. Okay. Unlike the affirmative defenses raised in Section 12, Rule 8, okay, those mentioned under Rule 6, Section 5B1, require the presentation of supporting evidence. Kunwari, the-raise mo is already paid, no? Release payment. Kadalasan yan, kailangan mong pakita ng ebidensya. Kaya the court may on its own calendar it for hearing. Unlike yung lack of jurisdiction over the person of the defendant, hindi naman magprepresenta ng ebidensya yun. Titignan lang ng court dun sa sheriff's return kung tama ba, kung nag-substituted service of summons, okay, dapat nang hindi nag-personal service of summons. Okay, now, what will happen? Okay, if the affirmative defense is denied, the order of denial shall not be subject to a motion for recon, shall not be subject to a petition for certiorari, prohibition, or mandamus. The remedy is for you to go to trial, and in the event of an adverse judgment, you appeal the judgment and raise as one of your errors the denial of your affirmative defense. Now, paano naman kung grinant? Okay? Please take note, okay? Pag grinant, you look at your Rule 15, Rule 15, 12C. If it's a grant, okay, you cannot file a motion for reconsideration, since any action of the court on the affirmative defense cannot be subject to the motion for reconsideration as stated under Rule 15.12c. Okay. So pag grinant, okay, hindi naman, siguro hindi itatanong to kasi ang remedy ay nasa Rule 41. Okay, kasama ata pala ang Rule 41, sorry. Certiorari under Rule 65. If it's a, for example, if it's a grant, hindi mo pwede i-motion for reconsideration, okay, it depends, no? You can appeal it, okay, or a dismissal without prejudice, Rule 65. Okay, kung dismissal without prejudice yan, it is going to be what you call this Rule 65. Now, the order granting is in the nature of a final order, as it leaves nothing else to be done by the court. Okay? Any questions na sanay ako na may kausap ako. Okay, anyway. So, do not set a hearing on your affirmative defenses. That is a prohibited pleading. Huh? Okay, now, let me talk about failure to plead. Okay. General rule defenses and objections not pleaded after in a motion to dismiss or in the answer are deemed waived. Exceptions, lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. Okay. Failure to state a cause of action is different from failure to prove a cause of action. That the complaint fails to state a cause of action, it refers to the complaint itself, and the remedy is you file an answer and raise an affirmative defense stating that the complaint fails to state a cause of action. When you say failure to prove a cause of action, it means the case went to trial, the plaintiff failed to prove the cause of action by evidence, and the remedy will be a demurrer to evidence. Okay. Okay, now let me now go to default. Okay. Default, there are dual stages of default. Okay. Can you just give me 1 minute lang to catch my breath? Huh? 1 minute, just 1 minute, please. Okay. Because I know, but at 5 I'm supposed to stop, but just give me 1 minute, please. Okay. Okay. 1 minute, only 1 minute. Just get. Kenny. Okay, now. Okay, now let me go to, okay, let me go now to default, okay? This is important, default, okay? Now, there are 2 stages of default, okay? First, okay, declaration of order of default. Then you have judgment by default. Bakit kailangan natin alamin yung 2 stages na yan? Kasi iba ang remedies dyan. Okay. Unang-una, paano ka ba madi-default? Okay. Default, okay, default is proper when there's a failure to file an answer within the reglementary period. Under the new rules, the period to file an answer as a general rule, kasi depende kung paano sinerve na ang summons eh. Kasi kung ang sinerve na summons is through publication, as a rule 60 days, di ba? Pero kunwari, personal delivery, okay? Personal delivery, you're given a period of 30 days within which to file your answer. You can file 1 motion for extension of time to file an answer for 30 days. And that's it. No other motions for extension of time is allowed. Is allowed under Rule 15. So you were given a period of 30 days within which to file an answer. You did not file an answer. Then the plaintiff now can file a motion to declare the defendant in default. And the motion, and what are the requisites before a declaration of default can be issued? The court must have validly acquired jurisdiction over the person of the defending party, either by service of summons or voluntary appearance. Number 2, the defending party must have failed to file his answer within the time allowed. 3, the claiming party must file a motion to declare the defending party in default. So ano ibig sabihin? Hindi pwede motu proprio i-declare ng court yung defendant in default. And then finally, the claiming party must prove that the defending party has failed to file an answer within the period provided by the rules. Bakit ko ginagamit ang defending party, hindi defendant? Because the plaintiff can be declared in default. How can the plaintiff be declared in default? If the plaintiff fails to file an answer within the regulamentary period to file an answer to a permissive counterclaim. Okay, what's a period to file an answer to a permissive counterclaim? 20 days from the receipt, okay, of the order granting, okay, the admission of the answer containing the permissive counterclaim. Okay, now what is the effect of an order? So nag-file si plaintiff because the defendant failed to file an answer within the regulamentary period. So the plaintiff now files a motion to declare defendant in default. Okay. Siguro allow me to share my screen para mas madali kong. Okay. Okay. So okay. Now, summons, serve, okay. Then of course you get a copy of the complaint. Okay. This is now your deadline, okay, to file answer. No answer was filed. So anong ginawa ni plaintiff? Plaintiff filed a motion to declare defendant in default. Please notice motion under Rule 415, you don't have to have a notice of hearing anymore. The court may, okay, or because this is a litigious motion, may or may not set it for hearing. Okay? But the defendant is given a period of 5 days within which to file an opposition. So hindi na kailangan ng notice of hearing because precisely the court may or may not set it for hearing. But even if it has not been set for hearing, the defendant, because this is a litigious motion, is given a period of 5 days within which to file. Okay, within which to file. Okay, now, nag-declare na ngayon siya in default. Okay. Walang sagot. Anong mangyayari? Mayroon ng order of default. Okay. After the order of default, okay, anong magkakaroon? The court may on its own without need of presentation of evidence, or the court may allow you to present evidence ex parte. Or on its own, okay, decide on the merits, okay, or allow you to present evidence ex parte. Okay. Now, ito yung second stage ngayon, magkakaroon ng judgment by default. Notice sa drawing, an order of default is an interlocutory order. Okay. Bakit interlocutory order? Wala pang judgment eh. May gagawin pa. Magdi-decide pa or ipipresenta ka ng ebidensya. Magpipresenta ka. Okay, now, what will happen? Okay. Okay. During this period, what will be your remedy? Okay. Ano magiging remedy mo against an order of default? Remedy. Basta your remedy, you can file it before judgment by default. That's been issued. No? So your remedy is you file, okay, an order, a motion to set aside order of default. Okay? Now, based on FAME, fraud, accident, mistake, and excusable negligence. At ang fraud mo dyan is extrinsic fraud plus your meritorious defenses. Dapat yan under oath. Oops. Okay. Now, so you can file that before judgment by default. Ngayon, kung may judgment by default at yun ang natanggap mo, ano yung remedy mo dyan? Okay, depende. Remedy mo by after judgment by default. The first one will be, of course, within a period to appeal, you can now file, okay, MR, MNT, motion for new trial, or appeal. When do you file that? Within the period. Okay. Okay. Or what you can do, after you have your MR, MNT, or appeal, hindi mo nagawa yan because, okay, of fraud, extrinsic fraud, accident, mistake, or inexcusable negligence, you can file a Rule 38 petition. Petition for relief from judgment, which you should file within a period of 60 days from the time, oops, you learned of the judgment, but not more than 60 days from the entry thereof. Okay. And when you say entry, it means that is the period of time where both of the periods of the parties have already elapsed and no appeal has been filed. Okay. Clear. So pag ang tanong, ano ba yung tungkol sa default, tignan nyo muna, ano ba yung tinatanong na remedy against? Order of default ba? Or judgment by default? Kasi iba yun. Iba yung judgment by default, iba ang order of default. Clear? Okay. Let me now stop sharing that. Okay. Now, what is the effect of an order of default? The first stage of default. Okay. The party declared in default loses his standing in court. This prevents him from taking part in the trial. While the defendant can no longer take part in the trial, he is still entitled, okay, to notices of subsequent proceedings. He may participate in the trial. The court may either proceed to render judgment, granting the claimant such relief as his pleading may warrant, or require the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. Declaration of default, therefore, does not tantamount to an admission because the court may even require you to present evidence to prove your claim. Okay, ano ang pwede pagka dineclare na in default at sinabi, okay, nagpresenta ka ng evidence. Okay? Anong klaseng judgment bang pwedeng i-render sa'yo? Okay. That which was proven. What is stated in the complaint and what was proven. Hindi pwedeng sumobra. Okay? Kung sobra-sobrang in-award sa'yo, you may want to file a motion for recall because of excessive damages. Okay. Now, kunwari dinimanda, there's one plaintiff, apat ang defendants. Okay? And all these four defendants were sued on the same cause of action. Same. One of the defendants filed an answer, the other three did not file an answer. Can this plaintiff now file a motion to declare these three defendants in default? The answer is no. The answer filed by the answering defendant will inure to the benefit of the non-answering defendant. Okay. I will repeat the extent of relief of judgment by default. The reliefs that may be granted in default situations are restricted by Section 3D of the Rules of Court. Okay. There can be no unliquidated damages. Okay. Unliquidated damages. Okay. 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 Now, let's talk about amended and supplemental pleadings. Okay, amended or supplemental pleadings. When you talk about amended pleadings, okay, all you have to do is really differentiate it. Differentiate. No? Amended pleadings. It refers to facts existing at the time of the commencement of the action. It results, the filing of an amended pleading results in the withdrawal of the original pleading. And it can be made as a matter of right as when no responsive pleading has yet been filed. So I filed a complaint, no answer has yet been filed, I can amend it, okay, as a matter of right. But I cannot amend it for the purpose of conferring jurisdiction to the court or for the purpose of making it appear that there is pala a cause of action. Hindi yan allowed. Now, ang supplemental pleadings refer to facts arising after the filing of the original pleading. It does not result in the withdrawal of the original pleading, and it's always with leave of court. Okay. Now, okay. Just remember those are the basic the amendment to conform, necessary to conform to or authorized presentation of evidence. No. Now, the court acquires jurisdiction over the issues even if the same are not alleged in the original pleadings of the parties. Now, if, for example, there was an issue that was not agreed upon or not even stated in the pretrial order, and one party adduces evidence and was able to permit and was able to induce evidence to prove an issue that was not agreed upon. Okay, and it was adduced and established with the implied consent of the other party. It is not a requirement that you have to amend your complaint to conform to the evidence presented. Okay? In other words, basta pumasok yung ebidensya, the court will consider that. But if you want to amend your pleading to conform with the evidence presented, that is all right. Okay. Now, Rule 11, you have to know that by heart. Huh? That is the period of time within which to file the responsive pleadings. But in connection thereto, for example, your deadline falls on a Saturday, then you are allowed by the rules to file it on the first business working day, which is a Monday. You want to ask for an extension of time to file an answer, for example. Okay. You reckon it from Saturday, not on Monday, because your real deadline is on a Saturday. Okay. And that's the ruling in the case of Luz versus National Amnesty Commission. Okay. 12, I will have to leave that with you. That's Bill of Particulars, no? 13. Medyo mahaba itong 13. Okay. Basta importante, you serve to the other party, you file it in court. Serve first a copy of the pleading to the other party, then file it in court. Huh? Hindi pwedeng file tapos hindi mo bibigyan ng kopya yung kabila. It is as if it is not being filed. Okay? Okay. Now. Okay. Also do not forget, no? You can serve it, okay, and file it, okay, by electronic mail if you are allowed by the court to file it by electronic mail. And number 2, you can serve it if all the parties agree that service can be done electronically. Okay. Now, let me go to 14 because to me this is maraming amendments dito sa 14. Okay. The court shall within 5 calendar days from the receipt of the initiatory pleading and proof of payment of the requisite fees, okay, issue the corresponding summons. Okay. So ano yung period of 5 days na yun? Because the court can dismiss the complaint motu proprio. On what ground? Lack of jurisdiction over the subject matter, jurisprudencia, res judicata, or prescription of claims. Okay? Action is barred by prescription. The summons basically is directed to the defendant, okay? To the defendant, signed by the clerk of court under the seal, okay? And it is actually a directive for the court, okay, for the defendant to file the answer within the reglementary period. Hindi siya nag-file a motion to declare defendant in default. Incidentally, okay, dun sa motion to declare defendant in default, pwede yan, okay, pagka-ordinary civil action. Pag small claims, rules on summary procedure, bawal, okay, bawal ang motion to declare defendant in default. Pag ang kaso, let's say, unlawful detainer, so covered yan by the rules on summary procedure, do not file a motion to declare defendant in default. What will you file? Motion to render judgment based on the pleadings. You cannot file a motion to declare defendant in default when the case involves petition for declaration of nullity of marriage, legal separation, annulment of marriage. Okay, now, who can serve the summons? The sheriff, the deputy of the sheriff, other proper court officer. The plaintiff can serve, provided that there must be failure of service of summons by the sheriff or the deputy. The plaintiff must be authorized by the court, and his authority to serve the summons must be stated in the summons itself. Okay? Now, I'm just going to discuss the highlights, no? Given that I have basically 25 minutes to end my lecture. Okay, now, what is important to remember are the different, okay, of course, it's always personal service, no? Personal service. Ngayon, kung ang personal service hindi ma-effect, pwede kang mag-substituted service. And how would you know that personal service cannot be effected? You follow the Manotok doctrine. It is trying to play the sheriff, for example, tried to serve it 3 days, three different occasions. There were 3 attempts, at the very least 3 attempts on 2 different occasions to serve the summons. Monday morning, sinerve. Monday morning, sinerve. Monday afternoon, sinerve. Then Tuesday, sinerve. Wala. Pwede ka na mag-substituted service of summons. So, substituted service of summons is allowed if for justifiable cause the defendant cannot be served personally after at least 3 attempts on 2 different dates. Service may be effected by leaving copies of the summons at the defendant's residence to a person of at least 18 years of age, so with sufficient discretion, and very importantly, residing therein. So kung dumadaan lang pala at bisita lang pala, hindi ka pwedeng mag-substituted service of summons dun sa dumadaan lamang. Okay. Next, by leaving copies of summons at the defendant's office or regular place of business with some competent person in charge thereof. And who is a competent person? A competent person includes, but is not limited to, one who customarily receives the correspondences to the defendants. So, by leaving copies of the summons if refused entry upon making his or her authority and purpose known with any of the homeowners association or condominium corporation or its chief security officer in charge of the community, or by sending an electronic mail to the defendant's electronic mail address if allowed by the court. If there is one provision that you really must read, okay, it's a must, is Rule 14. Okay? Kasi ang daming pagbabago dyan. Okay? Read it and try to remember it. So when resorting to substituted service, the following statutory requirements must be complied with. Number 1, the sheriff's return must show that there was impossibility of service of summons within a reasonable time. 2, specify the efforts exerted to locate the defendant. And 3, state that the summons was served upon him and upon a person of sufficient age and discretion who is residing in the place, okay, or a person in charge of the office or regular place of business of the defendant. It is likewise required that the pertinent facts providing the circumstances be stated in the proof of service or in the officer's return. Okay, now, okay. Let me just talk about when the, okay, because there's so many provisions there. Yung temporarily outside of the Philippines. There is one case kasi the husband was a resident here but he had to leave abroad because he's a seaman. So ang nangyari, itong summons, nag-file kasi yung wife ng petition for declaration of nullity, iniwan dun sa mother who is, you know, dun nakatira kasi yung seaman dun sa mother niya, umalis, iniwan sa mother. Did the court acquire jurisdiction over the person of the seaman husband? The answer is yes. Because the law provides, okay, when the defendant is temporarily outside of the Philippines, summons may also be served through publication. Yung may also means, pwedeng personal, pwedeng substituted kasi also. So the court acquired jurisdiction over the person of the defendant. Okay. Rule 15, huwag kakalimutan sa Rule 15, what are the litigious and non-litigious motions? And focus please on what are the prohibited pleadings. Notice, please, sa prohibited pleadings, you can only file one motion for extension of time to file an answer. You cannot file a motion for extension of time to file a reply, a rejoinder. Hindi pwede yun. Answer lamang. Okay? Now, at saka may mga prohibited pleadings nga. Please memorize that. Okay. Rule 16 was deleted. Rule 17 on pre-trial, on a dismissal of the instance of the plaintiff. Okay. What's important in section 1 is by way of right, di ba? By way of right. But please wait for the confirmatory order dismissing it. You have to wait it so that when you file it, hindi ka pwedeng sabihin na guilty ka ng forum shopping. Because without waiting for the confirmatory order, nag-refile ka na kung guilty ka ng forum shopping dyan. Okay. Section 2 and of course Section 3, okay? When you talk about Section 3, okay, that is a dismissal, for example, as I mentioned before, okay? As I mentioned before, when there's failure to comply with the order of the court, okay, to implead an indispensable party, and, okay, the plaintiff did not amend this pleading to implead an indispensable party, then the defendant can file a motion to dismiss pursuant to Section 3 of Rule 17. There's failure to comply with an order of the court. Okay. Now, Section 18 is also important. Why? Because this is your pre-trial. Okay. Sa pre-trial, do not forget, okay, that you are required to file a pre-trial brief. Okay. At least 3 days before the scheduled brief trial. Go crossing over to evidence, you are also required to file at least 5 days before, okay, the trial proper, you are required to file your judicial affidavits. Okay. Now, all pieces of evidence, documentary, and of course a list of other testimonial evidence must be submitted already or must be made available during the pre-trial. Can you reserve? The answer is yes. But there is now a way to reserve it. Okay? When you say you have to reserve, you have to identify the person, the name of the person, and the gist of his testimony. You also have to identify specifically the document you are reserving and the purpose for which it will be submitted. Hindi na pwedeng general reservation. You reserve the right to present additional testimonial or documentary evidence should the circumstances warrant. That is not allowed. There is a way to, okay, make the proper reservation. You don't do that proper reservation, you will not be allowed. Okay. Now, also, do not forget that if there's failure to appear during the pretrial, it will result in disastrous consequences. If the plaintiff failed to appear, okay, plaintiff and lawyer yan, they're required to appear. Okay. And if the plaintiff cannot appear personally, must execute a special power of attorney authorizing the lawyer to appear. Or if it's a juridical entity, same. The SecCert or a director's certificate authorizing the lawyer or somebody to appear during the pretrial. If there's failure to appear, what will happen? Then the complaint may be dismissed. okay, without prejudice to the defendant, prosecuting his counterclaim. Now, if it's the defendant who will defendant or the counsel or both fail to appear, it will also result to disastrous consequences, which is the plaintiff now can present evidence ex parte. He will not be declared in default. Okay, he will not be declared in default because there's an answer that was filed. But he will suffer the consequences of default, which means the plaintiff can adduce evidence in support of, the complaint. Okay, so that's Rule 18. Rule 19 is, please do not forget, isa pa to na pinaka-importante na requirement sa pre-trial. No? Sa pre-trial, the court may decide to submit the case for judgment on the pleadings or summary judgment as I said, on its own initiative. Hindi kailangang magkaroon ng motion. Kasi makikita ng court after all the issues have been discussed and after all the pleadings submitted, he can now decide whether the case is ripe for motion for judge to render judgment or to submit a case for judgment on the pleadings or summary judgment. Okay. The order of the court submitting the case for judgment on the pleadings or summary judgment is not appealable. Okay, not appealable. You cannot even file a motion for recon. You cannot even make it a subject of certiorari. No. Prohibition no. Okay? Hindi daw pwede yun. Okay? Anong mangyayari doon? Hintayin mo yung judgment. At pag nagkaroon na ng judgment at hindi ka and you're dissatisfied, you file an appeal and you assigned as one of your errors the order of the court, okay, submitting the case, okay, for judgment on the pleadings or summary judgment. Okay. Para naman masabing umabot ako sa 34 and 35, ano yung judgment on the pleadings? Tignan mo yung complaint, tignan mo lang yung answer, basahin mo. Walang issue. There is no issue at all. Okay? In other words, halos lahat inadmit yung material allegations of the complaint. So why will you go to trial? Okay. Motion for summary judgment. You complain. There is the answer. Okay. There appears to be an issue, an ostensible issue. Pag sa may issue. But because of depositions, affidavits, and other documentary evidence, this ostensible issue was unmasked to its very core that the issue pala is what? The issue is specious, okay? Or it is a non-issue at all. And therefore, okay, the case can now be submitted on judgment on the pleadings. Okay, JDR, court annex mediation, mandatory yan for those matters that can be subject of compromise. Court annex mediation must be terminated within a period of 30 days. JDR, if there's failure of court annex mediation, the court may decide, okay, to refer you to another judge who will handle the judicial dispute resolution. Okay. So, okay, what is important in intervention? Okay, when you want to intervene, it is a remedy by which a party not originally impleaded in the proceedings becomes a litigant therein to enable him to protect or preserve a right or interest which may be affected by the said proceedings. And what are the requisites of intervention? There must be a motion for leave to intervene filed before rendition of judgment by the trial court. Number 2, the motion must show in the motion that he has a legal interest in the matter in litigation or in legal interest in the success of either or both of the parties, legal interest against the parties, and move on is so situated that he may be adversely affected by a distribution or other disposition or property in the custody of the court or of an officer. But that legal interest must be actual, material, and direct, and of immediate character. Hindi yan pwedeng speculative. Okay. Now, okay. Don't forget viatory right. What is viatory right? Viatory right, you cannot compel in a civil case a person to testify if he lives 100 kilometers away from the court? What is your remedy pagka this witness is you're calling, invokes his viatory right? Mag-deposition na lang kayo. Okay? And when you talk about deposition from Rules 23 to 29, okay, ang importante dyan sa Rules 23 to 29 ay mag-apply kayo. It's an ex parte motion for, leave of court for you to be able to conduct your interrogatories or depositions. Do not forget your Rule 29 because your Rule 29 will tell you, okay, the consequences if you fail to avail of or even respond to a request for a mode of discovery, okay, or if you were ordered by the court to comply with a mode of discovery. So do not forget Rule 29. Okay. So in Rule 30, okay, Rule 30, okay, I think I can leave Rule 30. Okay, I can leave Rule 30 with you, and 31, what I want to address is the rule on the mirror to evidence. Okay. When you speak of the mirror to evidence, you file a demurrer to evidence. Okay, the only ground for demurrer to evidence is upon a showing that upon the facts and the law, the plaintiff has shown no right of relief. Why? Because on the basis of the evidence presented. Okay, evidence presented. Doon sa evidence presented, hindi niya na-prove yung cause of action niya. Now, what is the effect of a denial on your demurrer to evidence? You have the right to present your evidence. An order denying a demurrer to evidence is not appealable because that is interlocutory. Okay? Now, what is the effect of a grant? Grant means it will be dismissed. So what is your remedy? Appeal. But when you appeal, the appellate court if the appellate court reverses the order granting the demurrer, then, okay, it will not be remanded for the reception of defendant's evidence. The appellate court must decide on the basis of the evidence submitted by the plaintiff. In other words, there's already a waiver of right to present evidence. Okay. Please take note that in civil cases, defendant need not ask for leave of court. In criminal cases, may be filed with or without leave of court. However, leave of court is necessary so that the accused would present the evidence if the demurrer is denied. In civil cases, if the court finds the plaintiff's evidence insufficient, it will grant the demurrer by dismissing the complaint. But what is the effect of the grant of demurrer in criminal cases? Okay, if the court finds the prosecution's evidence insufficient, it will grant the demurrer, thereby acquitting the accused. Okay. Now, what is the effect of denial? If the court denies the demurrer in civil cases, defendant will present his evidence. On the other hand, if it is in criminal case, if the court denies it and the demurrer was filed with leave, the accused may present his evidence. But if the demurrer was filed without leave of court, then the accused can no longer present his evidence and submits the case for decision based on the prosecution's evidence. Okay, now, so that's 35. Now, okay. I have 5 minutes, so I might as well share with you what my observations are with respect to the hearing yesterday, to the exam yesterday, okay? Notice that it's all back to basics. Okay? So if I were you, given the scope and the breadth of, civil of remedial law, okay, go back to caudals. Okay? Dahil nga ang haba okay? Go back to caudals. Okay? And make sure, okay, that you read the caudals, isa puso niyo yan, and if you have notes, then go to it. Okay? Please make sure that your answers are not kilometric answers. The questions yesterday, if the trend is still going to be the same, would require only short, simple answers. The longer it is, I think, then that means you are not answering it right. Okay? Number two, please do not leave a question unanswered. Okay? Because again, may masagot ka lang, may points ka na eh. Wag niyo pong lalaktawan yan. Okay? Read the questions carefully. Now, if it is quite long, because I noticed that there were, medyo, hindi naman long, very long, no? may mas mahaba-haba ng konti. Tapos may nabasa ko, pagdating sa dulo, iba yung tanong pala kakaiba. Basahin niyo muna yung tanong, saka niyo balikan. So that when you read the question, you should be guided accordingly. Okay? And above all, okay? Pray. Okay? Study as if you've never studied before and pray as if everything depended on God. Today will be the last day. In a few hours, you'll go back and take your exams. And after that, you can rest. You will wait. And definitely, I will get to see you when you raise your hand and when you say you're the lawyer's oath. I'll see you at oath taking. Thank you very much. Okay, thank you. Okay. God bless you all. Excuse me.
Hi, Dean. Sorry. Thank you very much for extending your lecture until today. To everybody watching, we hope that you learned a lot from Dean's extended lecture today. We would like to mention that our event partner, Rex Bookstore, recently released a free digital copy of Bar Prep, Ready, Set, Pass, a light read on useful tips for the bar exam. I mean, it has already started, but you may always refer back to it to be able to, keep yourself calm and collect